In 1988, there was a problem. Vaccine manufacturers were swamped by so many lawsuits related to their products that they threatened to stop manufacturing them. Congress was convinced that vaccines were so important to public health that they had to be protected. In response, they passed the National Vaccine Injury Compensation Act. However, there were two very serious problems that Congress apparently didn't bother to consider. The first problem was a question that Congress didn't ask. Why were so many people suing vaccine manufacturers? Sure, some of the lawsuits may have been frivolous, but since many of those suits were settled for the petitioner, doesn't it beg the question why? Were that many people being injured by vaccines? Were the number and size of settlements a serious impact on the manufacturers, enough to put them out of business? And if that many people were injured by the vaccines, was it possible that the problem was in the vaccine, not the lawsuit? Into this problem steps Congress, with more than a little lobbying by the vaccine manufacturers, I'm sure. That's where problem number 2 raises its ugly head. You see, the Vaccine Injury Compensation Program law includes: no person may bring a civil action for damages in an amount greater than $1,000 or in an unspecified amount against a vaccine administrator or manufacturer in a state or federal court for damages arising from vaccine-related injury or death associated with the administration of a vaccine after October 1st, 1988. And no such court may award damages in an amount greater than $1,000 in a civil action for damages for such a vaccine-related injury or death, unless a petition has been filed in accordance with Section 300AA-16 of this title for compensation under the program for such injury or death. This was not the last law passed by Congress to claim immunity for vaccine manufacturers.